Hello everyone. So in the previous video, I have talked about in detail about the basics of law of limitation and we have discussed section 4 and section 5. So in today's video, I will explain you the gist of section 6, which is legal disability, and section 3. So both of these sections are very important in law of limitation. So what does section 3 states that in section 3, it specifically mentions that no suit, application, or appeal shall be entertained by the court, and the court will in itself dismiss the suit, application, or appeal, even though the limitation has not been set up as a defense. Which means that if the time is expired, so if the court sees that it's prima facie visible that the time of this application, suit, and appeal is expired, so on the prima facie evidence, the court will dismiss that appeal, application, and suit even though the defendant has not proved that the limitation is period is over. So if prima facie it looks on the plaint, so that court can remove and can reject that suit and cannot entertain that. Now, in section 3, how suit is instituted, it is mentioned in detail. So first of all, it says that suit is instituted when the plaint is presented before the proper office. So on the filing counter, properly you have presented the plaint, then it is accepted and suit is instituted. First point. Second point is that if in the case of pauper means an indigent person who doesn't have much income and much who is not able to pay the court fees. So in that case, the proper has to present a leave application and then the suit will be instituted. Third thing is that in case of winding of a company, then the claimant who is claiming the money has sent a notice to the liquidator, then the suit will be instituted. So in this circumstances, section 3 will apply, and the main aim of section 3 is that even if the law of limitation defense is not been set up by the defendant, still in that case the limitation act, the court will see that if prima facie it is visible that it's expired, so court will remove and court will bar that suit, application, or appeal. Section 3 is clear, I hope. Now if you'll give a reading into that, you will understand. Section 6 is very important. Section 6 states legal disability. So if legal disability is there, so reckoning period will not start until the legal disability of that person removes or ceases to exist. For example, your cause of action arises today, but you are disabled, means you are of minor age and any insanity is there. So till you become major and insanity is over, reckoning period will not stop. And after that disability ceases, you can file an application appeal suit in the court of law. So the period will extend and will give you time after the cessation, after the cessation of the expiry of your disability and the cessation of your disability, then you can file that suit, application, or appeal. So section 6 talks about this thing. This is the first thing. And in second part, what it talks is that in case the disability, one disability is over, but the second disability still exists. Take case of age of minor age you are of and you are mentally unstable. So minority is over, now you become of 18 years, but still you are of unsound mind. So when the unsound mind, that disability ceases to exist, only then reckoning period will start, and then you can file your suit and application before the court. And the most important thing, if you die and then if the reckoning period is not started, as soon as you die, then the legal representative will take over the case, and from that period the limitation period will start, prescribed period will start, reckoning period will start. So, and in what case the legal disability, in case the person has died and the legal representative appointed by the court is also of disability, so after that disability ceases to exist, you can file a you can file a case in the court of law. So legal disability means that as soon as the legal disability has ceased, then you can go to the court and file an application suit. Only in that cases the court will allow it. So legal disability has to be ceased. And in case where you went to the court and the legal disability is not ceased, you cannot approach the court for your remedy. This is the important thing in section 6. And once the reckoning period starts, it will not stop in any situation. That is taken into account in section 9 of the limitation act. So if once the reckoning period starts and then the legal disability arises, in that case reckoning period will not stop for you. That is section 9 clearly says about that. So section 6 basically aims at legal disability. Once the legal disability gets ceased, you can file an application suit and reckoning period will start from that point of time only. So I hope now if you'll give a reading to these sections, you will easily get it. Thank you so much.